She is not to, right now, Ms. Ramsey is here.
People versus Angelica Ramsey, case number 235251.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Jason Thompson, on behalf of defendant Angelica Ramsey. Your Honor, by way of pretrial, prosecutors made an offer to dismiss the third habitual offender notice and the count 2 if defendant were to plead guilty to count 1. I've spoken about that plea offer with my client. I understand she does not want to enter that plea today. I'd ask the court to set another status conference.
So does it look like we're going to be going towards trial?
I think we'll have a more definite answer at the next status conference, Your Honor.
Okay, Ms. Coke.
Your Honor, we are prepared to go to trial. I will be filing a 609 notice. Ms. Ramsey has a retail fraud third and a felony false report. For sure, under the statute, the felony false report comes in the second. Retail fraud will have to be reviewed by the court. We are prepared for trial other than that.
So I'll set this for a plea cutoff to 30 days. Between now and then, Ms. Ramsey, just continue to talk to Mr. Thompson. And when we're here for the next hearing, I'll need you to make a definite answer whether you want to accept that plea agreement or go forward towards trial. And that'll be an important date because that'll be the last time to enter a plea. If you don't want to do it at that time, it's fine, but we'll go forward for trial and there won't be any further hearings after that. So I'll need you to have made a final decision. Okay.
Sure.
Ms. Coke, anything further?
No, Your Honor.
Nothing further. Thank you.
Thank you, Mr. Ramsey. That's all. Versus Jenny Haller or Haller.
Sierra Coke on behalf of the people.
Richard Trush on behalf of Ms. Allen.
Mr. Ray.
I don't believe he's here yet.
Or at least I got Mr. Lamata.
Your Honor, did you admit Ms. Wilk into the proceedings so she can monitor at court?
Yes, she's there.
Okay, thank you.
Okay, people versus Lamont, case number 194499225099225. Records reflect Mr. Lamont's in the courtroom today. I can have counsel.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Richard Trish on behalf of Mr. Lamont.
Mr. Trish, how did we want to proceed today?
So, Your Honor, I think we're here for both the status conference as well as the probation violation hearing. I would indicate, as far as the probation violation hearing, it's our intention to proceed forward to a contested hearing on that. My understanding is I don't think that the probation department's ready to proceed with that today since Mr. McCall is not here. And that's fine, but I don't believe that there's any value in holding off in terms of like a global resolution of things.
Okay.
I think it's a hearing we need to proceed forward on. Likewise, in regards to the underlying felony matter, we'd be asking the court to set a jury trial.
Okay. Ms. Coke, about that, how much time we need to set aside for the probation violation?
I would say 30 to 45 minutes.
Mr. Trish, do you think that would be sufficient?
I imagine so. I can only assume the prosecutor had 83 witnesses. I don't imagine any of them will be particularly long.
Okay, so we'll set that for 1 hour hearing at the court's next available date. And then in terms of the trial in file number 235225, Ms. Coach, do the people need any particular period of time to be ready for trial?
No,
No.
And then Ms. Coke, how many days do you think we need to set aside?
I think we can do it in one day, Your Honor.
Mr. Trish?
I would tend to agree. I mean, I expect that it's, as far as the proofs, it's probably gonna be substantially similar to the violation hearing. It's a situation where there's a limited number of witnesses.
We'll set it for a 1-day jury trial at the court's next available date. We'll have it set. Conference prior to the trial. And then we complete a motion cut off. So any other scheduling issues that I can address for people today?
No, thank you, Your Honor.
No, thank you.
Okay, so Mr. Lamont, it's just important that you stay in touch with Mr. Trush. We'll send out notice of both the trial dates as well as the date of the hearing on the probation violation. Go forward from there. Thank you.
Thank you, sir.
Are you ready on this Schultz's case?
Yes.
Okay.
One of the shows.
We're a little early. This not set until 2:30, but be ready to take care of that. This is People versus Schultz, case number 235194. Directed to reflect the Schultz is present here in the court today. I get counsel.
Sierra Coke on behalf of the people.
Thank you, Honorable Member, very much on behalf of Ms. Deborah Schultz. She's in the courtroom, she's standing to my left.
This is set for a final status conference. We have trial date set for December 14th, 15th. Mr. Germer, the hour we go forward.
Just Ms. Schultz is going to ask that we go forward with the trial. It's set for the 14th and 15th.
Okay. All right. So Ms. Schultz, I just want to make sure that you understand that today would be the last day for the court to accept any pleas to any lesser charges.
She can't hear you, Judge.
Oh, I'm sorry.
It's me.
Yeah, you understand that today is the plea cutoff, so the court won't accept any pleas to lesser charges after today.
Right.
Okay, and it's your wish to proceed to trial?
Yes.
It is, okay. So we'll have the trial remain scheduled for the 14th, 15th. I'll just ask counsel, Ms. Coke, if you could submit your jury instructions and verdict form. Mr. Germer, if you just submit any objections or additional or different instructions,
Okay.
submit a full set. Ms. Schultz, on the morning of trial on December 14th, you need to be here by 8:30, and then we'll get started right away, okay?
Okay.
And then you need to make sure you stay in touch with Mr. Germer so that you're
Yeah.
prepared to go forward.
I do.
All right, Ms. Coke.
Your Honor, I just want to let the court know, this is stacked, and I believe this is the newer of the two. Mr. Shepherd is folder and on the same day. So I spoke to Mr. Grimuthi. He represents Mr. Shepherd right now as well. So he's going to contact Ms. Schultz at the end of today and let her know which trial is going.
Okay, very good. Yeah, I knew that.
Go ahead.
There's moving parts here yet, but we'll
Right.
indicate that this one is going to go at some point. So, all right, thank you.
Thank you.
Here's my new number.
Let's come off.
I believe so.
Okay.
Butts is off the docket.
Okay.
All right, Mr. Thompson, can I just see if Mr. Church is ready at 1:45?
Yes.
Thank you.
And Mr. Bruchow,
Bruchow?
he's next door. He's in the
Yes,
jail.
he's available.
No, we can take that. Mr. Church, are you ready on Mr. Ray's matter?
We are.
This is People versus Ronald Ray, case number 235-204. Mr. Ray's present here in the courtroom.
Here, how can be after the people?
Thank you, Your Honor. Richard Church on behalf of Mr. Ray. Your Honor, we're here for a status conference. I would indicate we have a resolution for the court. The prosecutor had offered Mr. Ray if he pled to a simple assault and battery, the 90-day misdemeanor, they dismissed the more serious charge. I've had an opportunity to go over that with Mr. Ray, and it's his intention to take advantage of that today.
All right, Ms. Koch, is that a correct statement of the offer?
Yes.
All right, Mr. Ray, have you had a chance to talk to Mr. Church about this plea agreement?
Yes, I did, Your Honor.
And is that how you want to proceed today?
Yes,
You raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
yes,
Ray, are you currently on any kind of probation or parole?
no,
As Mr. Church indicated, you understand the maximum penalty that you could face for assault and battery is up to 93 days in jail. And that-
yes.
With that maximum possible penalty in mind, what is your plea to that charge today?
That would be guilty. Guilty.
Okay. Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you want to. You understand all those rights. You understand that you're going to be giving up and waiving those rights by pleading guilty.
Yes,
Has anyone threatened you with anything to get you to plead guilty?
no,
Has anyone promised you anything other than what we said here in court today?
no, sir.
Is it your own free choice to enter this plea?
Yes,
Are you pleading guilty because you are guilty?
yes, I guess so. Sorry, I didn't mean that.
No. Back in May 17th of this year, is that correct?
Somewhere around there, yes.
And Mr. Tricia, you're familiar with the facts here. Can you ask some questions?
I
Thank you.
am. So I honor about that date. Did you have an interaction with a Mr. Engeloff?
I believe that's his name. I don't know, but yes.
And during that time, there was some interaction between you and him that took place in a vehicle?
Yes, yes, I mean, it's right at fire burning levels.
And did there come a point in time when you left your vehicle?
When I left my vehicle, it was holler, yeah.
Okay. And when you did that, did you open his car door?
Yes,
And were you yelling and screaming at that time?
yelling and screaming.
Were you acting aggressively at that time?
Well, no,
You said you were yelling and screaming. What are you doing with your hands?
I just held the door open and looked in and hollered at him.
Do you think a reasonable person in that circumstance might have been afraid or in apprehension that you might assault them?
Well, he might have been, because I don't know him, but he didn't have to do what he did.
Is it fair to say that your interaction with him on that day, you weren't talking to him calmly like you're talking to us now?
No,
You were agitated.
I hollered at him yesterday. I was in bed at 10:30 at night.
All right, thank you. Ms. Koch, are you satisfied with the factual basis?
Yes, Your Honor.
Ms. Koch, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Truish?
More of none, Your Honor.
Ms. Koch, are the people satisfied that the court has complied with statute for willing to take you to this plea?
Yes, Your Honor.
Mr. Truish?
I'm satisfied.
Mr. Ray, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. Ms. Koch, you have, the victim here is going to want to address the court.
I do not know the answer to that. We did confirm with him that he was okay with this plea, but we didn't ask him whether or not he was going to address the court.
Okay, so we'll set the sentencing hearing separate date. You'll get a notice of that date, right?
All right,
Just make sure that you stay in touch with Mr. Truish. And I don't think I need a PSI
No.
on this, probably based on allocution and what I've heard here so far. I think we'll probably, I'll have it on back, so. Again, Mr. Ray, just make sure you stay in touch with Mr. Truish. We'll send you that hearing date.
all right.
Thank you.
Yep, thank you.
Five two zero seven.
You're cooking.
Reflect Mr. Bush's record here in the courtroom today. Take time set for sentencing in this case. Mr. Bush, did you have a chance to go through the pre-sentence report and talk to Mr. Thompson? Austin, are there any additions, deletions, or corrections?
Yes, Your Honor, if you go to the second page one under evaluation of the man, PSI claims that in the fourth paragraph, last sentence, it indicates he, Mr. Bruce, should disagree with the policy of having to leave during the daytime to look for work, housing. And Mr. Bruce has indicated to me that's was not the motive for that other offense. He was upset about having to be living with, essentially what he would call drug using criminals. And he was, that was the upsetting thing, not the having to leave during the daytime. So he believes that should be changed, Your Honor. So,
I personally have no information regarding that issue.
That was just the interpretation I had after the interview. That's why I included it, but we can change the wording if necessary.
I'll just strike that sentence at the end.
Okay.
Thompson will have to, that remedy that problem. Okay. So we'll take that sentence out. Any other corrections?
no, Your Honor, I believe that's the correction.
Is there any changes to the scoring of the guidelines?
I did file a written challenge to the scoring, Your Honor. I know there was some, I know you weren't fully staffed last week. I have a paper copy of it here. It's one objection to one. I sent this out end of the day, November 16th by email.
Okay, that's fine. I didn't get it, but let's just go through what it is, which.
Sure, Your Honor. It's OB12. And as the court knows, OB12, the proposed scoring is to assess 5 points for 2 or more contemporaneous felonious criminal acts involving other crimes. And I'm sorry, and we believe it should be 0 because it's 2 charges, 2 felonies, but they're the same act. The act is he went to a home, he was brandishing a knife, and this individual involved, this Willie Roberts, was a witness. So he pled guilty to retaliation against a witness. as the prosecutor charged it, that same act could also have supported felonious assault, but we believe that they're the same act. And the OB-12 is very clear. That's the language they use, Your Honor. And we believe it requires distinct acts to score it for additional contemporaneous felonious acts. We believe there's only one act at issue in this case. That's OB-12, Your Honor. If I'm correct, his points would drop to 20, his OB level would drop to 2, and the guidelines would change to 7, Your Honor. So, I'm saying, my objection is upheld.
Your Honor, this is an interesting issue because one of the examples in Mr. Thompson's brief is the cases where you have larceny and they you can charge larceny several different ways, like larceny in a building, home invasion, that type of thing. But in this case, what is interesting is that it is one set of events, but they have different elements. So he could commit the felonious assault, showing up at someone's house, brandishing a knife at him, without ever being related to a separate case, or the intimidating on the other case. He can commit the retaliation, showing up at someone's house, threatening them for testifying, etc., without having the knife in his hand. So although I understand Mr. Thompson's points, and him and I discussed the legal sides of both of them, I think that these two charges are very different. You don't have to have the same elements for either of them. And because of that, even though it's one act of having a knife and threatening somebody or retaliating against them, which is what Mr. Brusha was doing. So I do think it was properly scored.
So what you're saying is, yes, it's one set of circumstances or one act, but it could result in the same fact could result in two different crimes because the elements are different and the actions could fit within the elements of either or both.
Yes, for the retaliation, there doesn't ever have to be a knife. For the felonious assault, there doesn't have to be a retaliation against a witness. In this case, he used the knife and retaliated against the witness, and that's why it was charged that way. I do try not to overcharge. I understand some prosecutors charge all the things they can. I really try hard not to do that. Mr. Thompson, I know we disagree about this OV, so leave it to the court.
Do you have any response argument?
I think that's the double jeopardy analysis, but under the case law I cited, when scoring OB-12, the court must look beyond the sentencing offense and consider only those separate acts or behavior that did not establish the sentencing offense. Language of OB-12 clearly indicates that the legislature intended for contemporaneous felonious criminal acts to be acts other than the sentencing offense and not just other methods of classifying the sentencing offense. So one of the cases is somebody's given drugs, they die, prosecutor charges manslaughter and delivery causing death. They attempt to score OB-12 because there's a contemporaneous criminal acts because there's multiple charges that can be supported by giving somebody drugs that results in a death, and that was overturned. So that's the basis of our objection, Your Honor. It's a hard copy of my objection or not. I don't have anything further. Thank you.
And I had this issue come up. First of all, I want to acknowledge that this isn't really a factual issue. It's not a question of the court finding a factual basis to support the scoring. It's a legal issue and whether or not uncontested facts can be scored under OB-12. And I've had this issue come up in different cases. And it's my view, and I agree with Mr. Thompson's view, is when you have one act, or one set of circumstances that give rise to multiple charges, it's not contemporaneous felonious criminal acts as contemplated under OB-12, the scoring of 5 points. So the court's going to grant the challenge by Mr. Thompson, score OB-12 at 0. Does reduce the total points to 20. Reduces the OB level to results in that of 7.
I agree with the court's math, Your Honor. That's how I calculated it.
Any other challenges?
No other challenges, Your Honor. The other conversation I had with Mr. Bruce, who has been pursuing care with CMH for his mental health conditions since he's been in jail. So in terms of page 11, treatment.
Coke, any objection to adding that? Under, health?
No,
Health section. Okay. Or order that be added.
Thank you.
Let's go. Deletions or corrections.
no,
Any challenges to the scoring of the guidelines?
no,
Do you have any victims that wish to address the board today?
no, Your Honor.
Anything on behalf of the people for allocation?
I think the recommendation, even with the change in the guidelines, is still appropriate. I do know that Mr. Brusher struggles with mental health. He has written numerous correspondence to my office. I can turn them over to defense counsel, but it's clear from reading them, they don't make a lot of sense, and he seems to struggle with his thought process. I don't know that prison is the right place for Mr. Bruscio. I think the recommendation here is appropriate. Thank you.
Mr. Thompson?
I also asked the court to consider this recommendation, Your Honor. I know there's some things that are negative about this case, and obviously the court's reviewed the PSI, but this is also a matter where Mr. Bruscio has, again, been pursuing CMH treatment. That's clearly part of the whole picture here. And really, that's where this thing needs to go. This needs to be getting CMH treatment, and I think that will help him greatly. He's got some, some very unfortunate background in his life, and he continues to deal with that from the mental health perspective. And I would ask the court to consider adopting the recommendation.
Just I will continue to be CMH because I feel that this one here in Grayling can help me where I've proceeded to see community mental health in Emmett County. They weren't doing me any good. That's why I had not seen them. That's why I was not going to see them in Charlevoix County. I now realize that there is a bench warrant out for me, which I did not realize. But Charlevoix was also telling me I needed to see CMH. I didn't feel that the CMH in Charlevoix County was going to help me because of the circumstances of what I was going through in Emmett County. But the one here in Grayling seems that they're going to help me greatly, where I didn't think that I was going to get the proper needs in Emmett or Charlevoix. That's the only reason why. And I've got to deal with Charlevoix. And when Charlevoix realizes that I'm seeing CMH here, it's going to help this out a whole lot more. That was one of their recommendations, that I see CMH. It didn't matter where, as long as I've seen them. This one here seems that they're going to help me in my mental problems of I got a 6-year-old daughter. This is affecting, and this is why I'm seeing CMA. It is greatly affecting my 6-year-old daughter. I do talk to her on a weekly basis. I can't have this in my daughter's life. This is too much drama for a 6-year-old girl to be going through. My daughter is very smart. She's going to dance classes. Next year she wants to do karate. I don't want to miss it.
I did read through the report, so I'm familiar with the circumstances here and your background as well. So in addition to listening to what you've had to say and what the lawyers had to say here, I've got a lot of information from the report as well. And number one, I think that as much as you can engage with CMH, I think that's really important. Kind of situation where you're going to have to spend more time away with your daughter. Because of your past history, you know, the guidelines are starting to go up and up. And in order for you to avoid going to prison, it's really important situations. Again, this sooner or later. County and community corrections isn't gonna be an option anymore. It just has to be prison. I don't think you want to do that. I agree with Ms. Koch. I don't think that would be helpful to you anyway. But that's kind of the direction it's heading if you don't follow up and continue to get help. I do think that the recommendation here, it's at the lower end of the guidelines. As you heard, the guidelines are 7 months in jail to up to 23 months in prison. The recommendation for 12 months is at the lower end of that. I think that accounts for your behavior in this case, and I think it also allows for that opportunity to continue going and treating with community mental health while you're serving your time here, as opposed to being in the state facility somewhere. So I am going to follow the recommendation and sentence you to 1 year in the Crawford County Jail. You have credit for 152 days served. Crime victims assessment of $130, court costs of $325, attorney fees of $350, and state costs of $68. You have the ability to please, Mr. Brochu, that these papers are going to explain to you what you want to do that, as well as how to request a court appointed lawyer to help you with.
Mr. Brusher, just initial this one to indicate you've received it. It's not the same as filing the appeal. You can do that later or not do it. Yep.
Just for the record of Mr. Brucci, I'm gonna date this for today's date.
Mr. Johnson, anything further?
Nothing further. Thank you.
Good luck to you going forward. Our next hearing is at 2:15 versus David Burr. We'll take a short recess until 2:15.
We're here, we're ready if you're so inclined.
So, do you have any items that you're going to wish to address the board on?
We're going to be withdrawing the plea pursuant to previous conversations. So I should be fairly quick and short.
Where's your then? We're on the record.
You're a Coke on behalf of the people.
Adam Burr, on behalf of Mr. Burr, first of all, I'd like to apologize for my attire. I was not expecting to be in court. It wasn't on my calendar. So it's supposed to be an office day, so I do apologize. I do have Mr. Burr Mertz here if the court would prefer something.
No,
Okay.
Thank you for the explanation.
I do apologize. At the plea, Mr. Burr entered a factual basis. Part of that agreement was that the penalties would include a 15-year registry and a sex offender registry pursuant to probation. The guideline or the SORA registry identifies 25 years, so that's inconsistent with our plea agreement. I had that conversation with Ms. Cope. I believe she agrees with that. That is not a part of our agreement, so that he would have the right to withdraw that plea. It is his intention to do that today.
All right, let's go.
Your Honor, that was the agreement. CSC fourth is generally speaking a 15-year because of the age of the individual, which of course we can't change. That makes it a different tier. And it is a 25-year. I understand he'll be withdrawing his plea out. Ask that this trial be set first and foremost on the court's trial docket as soon as possible.
All right. Let's go. How many days of travel?
One.
Just look to see how many. 2 days.
Yeah, I think I can do this trial in 1 day. Frankly, the defendant made admissions to everything, and I'm just going to put the officer and the minor child on.
Mr. Vernon.
Normally, I would agree, but the fact that this is a CSC, the jury is generally difficult. I think it's gonna be a 2 day, it's probably gonna be closer to a day and a half, but I think it's gonna run over, it's gonna be more than one.
I think out of prudence, I'm gonna set it for a 2 day jury trial. We'll set it at the court's next available date. I will set it for a final status conference immediately prior to the trial date, just to address any issues that may arise between now and then. But
I would ask the court to set it for at least 60 days out. We've been preparing for the plea, we really haven't been preparing for trial at this point. So I would ask for that opportunity to contact the witnesses. And have conversations with them.
yeah, I don't think I probably can't get it on the docket earlier than that.
Okay.
We'll get it set for the as soon as possible date that I can though. And Ms. Koch, I mean, in terms of the plea withdrawal, do you agree that under the court rules that Mr. Byrd?
I was not aware that he was going to do that today. We were prepared for sentencing. Mr. Byrne and I discussed it was a possibility, but I wasn't aware it was happening. But it is part of the plea agreement. We did agree that it, based on the statutory, and actually we both looked it up, that it should have been a 15-year, but it looks like it is 25 years under the MDOC regulations. So I think he has the basis to do it. I'd ask for, as I said, I'd ask for that trial as soon as possible and to take priority over all the other trials we have.
All right, so Mr. Vernon, I will ask you to prepare an order, just reflecting that there's agreement on the record that from a legal standpoint, he's entitled to draw a plea in that year.
We will draft that stipulated order.
The court will send out the trial dates. As the court's normal policy, Ms. Koch will submit your jury instructions and verdict form. Mr. Vernon, you don't need to submit full text, but any instructions that you're going to be asking for that are different than Ms. Koch's, in addition to or any objections that you have.
Okay.
And I'll ask that you both do that 7 days prior to the trial date. Ms. Koch, would you put that on?
Your Honor, could I ask that this not be stacked with any other case, or that if it is stacked, that it's first priority? I just don't want it to get the next available date and then it be stacked on something, that would take priority. So I just ask for it to be the first priority on whatever date it's set. I can tell.
Probably going to be stacked, but I understand that you'd like to have this have priority. So, okay, thank you. That's all.
Thank you. Thank you.
Mr. Germer, I know we're ahead of schedule. Your next matter is Mr. Russell. Yeah, on bond or not bond?
He's out on bond, it's a little bit clear, we'll check and see if he's here.
Okay.
Russell's not here.
Okay, we'll take a recess. We'll come back on the record at 2:30. We have Mr. Scarborough ready?
Yes.
People versus Scarborough, case number 235253. Executive counsel.
Sierra Cook on behalf of the people.
How did we want to go forward on this file today?
This is the first status conference in circuit court we've had. Mr. Scarborough resides in Kalkaska County. Kalkaska County has a sobriety court. There's some communication connection issues with Ms. Becky Gomez. So I know she's gonna coordinate and see if he's accepted in that program. Being the same circuit, I think we could work the other nuances out of whether we transfer it or how that works out. But that's kind of where we're at this point. So I'd ask for a short adjournment so he can meet with Ms. Gomez. She did reach out to me today with a new phone number that was assigned to her through sobriety. I'll do that to Mr. Scarborough as well. And then I can update the court with his new PO box address as well.
Ms. Pope, do you have any objection to adjournment?
Yeah, this case was charged, just for the record, in June. We did have a failure to appear in August. We had a defendant, we had a show cause. It's getting kind of old, so I'd ask that we have this resolved at the next hearing, or I will be pulling any plea offers.
So we'll set this for hearing in about 30 days. So between now and then, Mr. Scarborough, I need you to work with Mr. Mertz in this Friday board over in Kalkaska. I think 30 days should be enough time to get yes or no.
Correct.
So we'll proceed at that time. In terms of the updated address, Mr. Scarborough.
It would be PO Box 694, Kalkaska, Michigan. 49646.
Anything else on this file today? Ms. Pope?
No,
Sure.
No, sir.
People versus Russell.
I'm gonna check out briefly this area.
Ground record of People versus Russell, case number 235164. If I could have counsel.
Sierra Cook on behalf of the people.
I think on the web, there might be a Mr. Russell.
This was set for 2:30. It's now 2:47. Have you had any contact with Mr. Russell?
I tried calling Mr. Russell just today, no contact. I did speak with him last week. He's kept in contact with me prior to that. So I'm not sure why Mr. Russell isn't here. I intended to attend a plea today. We discussed no contest plea. I also indicated to him that there's a chance that based on the statute that it's probably going to be removed. Taken into custody. So he was aware of those things. I don't know that Mr. Russell, why he's here.
There is a jury trial set for next month. We would ask for a bench warrant for failure to appear and to take the jury trial off. I don't want to prep a child for a jury trial if it's not going to go, and if he's going to enter a plea, then it doesn't seem necessary to keep that on.
Yeah, so I think the court's going to ask that you prepare that bench warrant. And once Mr. Russell's apprehended, and we can work with the plea or he turns himself in on that warrant, I'd be happy to take that plea at some point prior to the next motion hearing.
And then why but the trial's off at this point.
No, I'm going to leave the trial on. We're still several weeks ahead of time, so we're going to leave that as scheduled. And once we get a hold of Mr. Russell, I guess we'll see where we go. All right, so Ms. Pope, I'll send that bench warrant once that's prepared.
Okay,
Can we just make sure that trial is not stag judge?
it's not.
It's not okay.
No. Okay, next hearing is set for 3 o'clock. I know Mr. Prentice has indicated that he was sick. I don't know, is he planning on?
I told him to drive down. I initially told him appear by Zoom, depending on what his diagnosis were at the urgent care. He does have bronchitis. And then Ms. Meadows said it's an in-person hearing, so I just told him to drive down. He's gonna be late, but he's gonna come down.
Okay,
That was about 2:20 and he was 15 minutes away, so I would assume another 30 minutes or so
okay,
from his slotted time.
all right, so, correct.
Scarborough.
And Mr. Gerben, I mean, if he's ill, I mean, I don't mind adjourning the hearing, I can't have people before, I don't want defendants choosing. That's
I told him to mask up and be here, so we can go forward with the hearing. That's entirely up to you and the DA because diagnosis if they put him in or otherwise.
Okay, record and People versus Arthur, Gone, case number 235160.
Sierra Coke on behalf of the people.
All right, this is the date and time, again, you can come right over.
Yes,
here
sir.
to the podium. This is the date and time set for sentencing in this matter. And you had a chance to review the report.
Yes, sir.
We had a chance to talk to Mr. Kermer.
Yes, sir.
Mr. Kermer, are there any additions, deletions, or corrections to that report?
Not to the report, Judge.
And it's misdemeanor, so no guidelines. Ms. Koch, I did receive a victim's impact statement that I had a chance to review prior to the hearing today. Matter there any additions, deletions, or corrections?
No, Your Honor, the restitution amount is the 1591.14, and I apologize. I had read the amount of the subtotal without the sales tax. That was the difference.
And is there a victim that wishes to address the court today?
He is not present today.
Anything on behalf of the people for allocation?
This case is hard. These neighbors clearly do not get along. I've been dealing with both of them. I've dealt with Mr. Gahn on a one-on-one basis for his kids in a juvenile case before this case came. It's sad to me when people live in this community and just can't get along. I don't know why Mr. Gahn would shoot out his neighbors, Kubotas. I just don't know why he would do that. This is going to cost him a lot of money, which I know he doesn't have. So he's putting himself in a position where he's looking at jail. He is a sole provider for his children. His children certainly need him to be there, and acting stupid, which is what he was doing, is not getting him anywhere. I appreciate that he took responsibility, that he wants to be an example for his children. But if him and this neighbor do not cut it out, we are going to end up with aggravated stalking and all kinds of other things. I think that maybe Mr. Gahn will take this time. He will think about what he did, and maybe they can both enjoy their property and living in our community instead of continuing this neighbor dispute. Thank you.
Thank you, Mr. Kermer.
Thank you, Judge. Mr. Gann has been remorseful for his conduct. He's sorry he came to this, took accountability for what happened. There's no objection to the restitution amount. He would make payments and pay that off. He's 56, no prior criminal record. I think for the last 3 years, he's resided next to this neighbor. And what Mr. Gann indicates is that he doesn't do anything that causes issues, but the problem that arises with the neighbor is that their properties butt each other, and there's constant property disputes, and they are in circuit court with their property dispute issues. And those arise from where the rocks are laid for the motel and his house is right behind it. Those constantly keep getting moved, or the victim in this case recently, where Mr. Gann turns onto his driveway to go up to his property through a box full of nails, hoping you get a flat tire. So this is just constant on both sides that continues. I think over the last several months, again, I'll remind the court that Mr. Gann initially was proper, since at least I've been with Mr. Gann on this matter. Some of the stuff has stopped out and subsided. There's no issues there. I don't anticipate any further issues from Mr. Gann. But it is unfortunate it's both ways. They're constantly calling the police, they're constantly calling the prosecutor's office, but that has subsided from Mr. Gann. I think I've given him some sound advice. He understands how to navigate some of these issues. And again, I think he's setting a good example for his boys. He has full custody of his boys. This is not what Mr. Gann wants to be or be part of. So I know he's apologetic, but I don't think we'll see Mr. Gann here again.
Mr. Gannon, anything that you wanted to say today?
Other than that, I'm sorry that this happened. And my attorney is correct. It's just a dispute over property line is all it is. And I have not talked to Mr. Bill for quite some time. I go out of my way to stay away from it because we just don't get along. And hopefully in the future, the property line will be decided by a judge because it's just never gonna subside on that issue. I don't argue with him about it no more. If he is breaking the law, then he should be in trouble for it. So I have called the cops a couple of times on him. But no, normally he's the one that calls the police on me, and I'm not doing anything wrong. It's like as if he's poking the bear to get a rise out of me to get me in trouble, so that way I do go to jail. And I'm not trying to do that at all, Your Honor. Like my lawyer said, I've completely changed. I've completely go around to not be around him and not see him. If I see him in the store, I walk out immediately. I just don't want no more arguing. I don't want to deal with it. I don't want to argue with no more. I just want it over. I want to move on.
I've read through the report, so I'm familiar with the information that's in there. It also gives a lot of information about your background and your circumstances as well. And these are, I agree with the prosecutor, these are tough situations. I have, I won't say a lot, but a few cases like this on my docket with different counties. And there really is no good way to solve it because there isn't a court in the world or a piece of paper in the world that can make people act reasonably with each other. You're either going to do it or you're not. And somebody can always find a way around a piece of paper. So as long as you guys are going to be neighbors, the only real solution is for the two of you, as she said, figure out a way to coexist. You don't have to like each other. You just have to not do things in relation to each other. And the other thing that I can say, and I really feel this is true, is in most of these situations, it's not all one person or all the other person. There's things going on together that creates this situation. And so, to the extent that you're instigating some of this, you need to stop that. To the extent that he's instigating it to get a reaction out of you, you've got to realize that and not.
That's exactly what I've been doing, Your Honor.
So, I hope that through this process that both of you guys are going to realize that it's not worth all the time and energy that you're putting into it. Spend that in ways that are more productive, more satisfying.
That's where I'm at now, Your Honor.
So I think the recommendation is appropriate, and the court is going to follow that. There's different ways that we can punish wrongful conduct. One of those ways is putting somebody in jail. The other way is through financial penalties. And I think given your lack of any real record, I think that a financial penalty here will address what happened in this circumstance. So the court is going to follow the recommendation and sentence you to 2 days in the Crawford County Jail with credit for 2 days served. Restitution amount of $1,591.13. Crawford County Clerk. $130. Court costs of $325. $50. State costs. Misdemeanor, so there, you do have the ability to seek an appeal of this sentence if you wanted to do that. You did want to do that, file the appropriate paperwork within the next 20 days. You want to think about it. If you do have questions, sure, be happy to explain that.
I don't think.
Sure. Otherwise, once you leave court today, you need to go next door to the sheriff's office to make arrangements. Pay those kinds of costs.
I meant to ask this at the beginning, but would the court be willing to put Mr. Gahn on a short-term probation to monitor the restitution payments, which is a big part of what the victim needs? We don't have a way to monitor any type of court cost or restitution here if they're not on probation, so it won't be enforced in any way.
Judge, Mr. Gann is on disability. I don't object to the probation, but it's going to add the probation fees on top. If there's a way to not have that probation oversight fees, then I don't object. Mr. Gann's not somebody in drugs, he's not drinking. I don't think he's gonna violate any of these orders. But for the purpose of restitution, if that's what they need to monitor, he's gonna make payments, he's on disability. It's gonna be $1,500 a month, somewhere between that range. We've sat and looked at his budget, and that's where each month it's gonna differ, he's gonna make those payments.
I don't know. I mean, I generally don't have an objection to probation for the purpose of monitoring restitution payments, but Mr. Haven, I mean, this is a misdemeanor. Is there some type of non-reporting? I don't want to add more fees on Mr.
The other thing we could do is,
I'd rather have them putting that money towards the restitution. than,
we could set a review hearing 90 days from now and have him check and see if the restitution is paid so that we have a monitoring
All right, that's
mechanism.
Okay.
I'm fine with that. I can tell the court as an officer of the court that he's not going to pay all of it, but there'll be a monthly payment. And he's going to pay it if you just monitor it in that fashion.
All right, so Ms. Koch, I'm gonna ask that, you contact my, Jennifer and ask her to set for restitution review here. In 90 days.
Okay.
And understanding that you may not be able to pay that all out, Mr. Sando, what we want to do is.
Yes, sir, absolutely, absolutely. And I won't miss a payment.
Okay. Okay, thank you.
Thank you.
Thank you, Judge.
Just like we talked, monthly payment. Whatever it is. Like we talked. Mr. Prentice is here. If I could just have 1 minute with him. Make sure.
Mr. Gunn, are you gonna be making a payment today? Are you making a payment today?
No, it'd be on the 3rd.
Okay, okay, I was just making sure, because if you were, I would take your money here and I'll go get you your receipt.
Roger that.
Okay.
Ma'am, I'd be on the 3rd. I'll be here like with bells on.
Okay, thank you.
Yes, ma'am. Thank you for that. Appreciate it very much.
Nope, my neighbors are far enough away.
Do we know what Mr. Prentice's condition is?
So, Judge, Mr. Prentice, come on up here, Mr. Prentice. He did go to the urgent care today. He has bronchitis, he's had meds. Mr. Prentice doesn't object to going forward with sentencing today. But again, I told him that there could be a jail component issue, you might have to report at a later date. Or if the court does something different, that's entirely up to the judge. So I don't know if the court has certain direction.
Ms. Koch,
Yeah, we would ask to go forward with sentencing. Mr. Prentice absconded on his case for over a year. The note from the hospital says that he has bronchitis and has been given medicine to treat it. If the court wants to give him a couple of days to, before he turns himself into jail, that would be fine, but I'd ask to just get the sentencing done and over with.
And that is what we have started initially when this case first started with, since he turned himself and he's been here at every court proceeding. We're ready to go to trial, but then we had a modified plea agreement that he took advantage of. He's here today. He was going to appear by Zoom, but he's fine that the court will give us certain time for him to come himself in as well.
I don't like that. I find that creates more problems. So what I'm gonna do, and I don't want somebody to. I do though, you know, they security of our jail staff, other inmates. So I am gonna reset this for sentencing at a later date. So Mr. Prentice, make sure that you stay in touch with Mr. Gerber and we'll send notice of the date and time of that hearing. I just want to make sure you confirm your address with us.
401 3rd Street, East Jordan, Michigan.
Yeah.
That's what I have to do, just 401 3rd Street, East Jordan, Michigan, 49727. And Mr. Prentice, I can tell you that since he turned himself in, I still in contact.
No, and I mean, you made that happen to come here today.
Yeah, sorry I was late.
No, so we'll reset it for another date. And about Mr. Woods, right, there's somehow.
He's supposed to appear by Zoom. He's the one who.
Mr. Wood would be Zoom.
Okay.
I don't.
I don't see him connected yet, so,
I will tell the court, I don't know if he's in jail down in Oakland County because we did report about his new conduct. I spoke to his counsel down there. But I've called her last week, I haven't heard back from her, so I don't know if he was picked up on that or not.
okay. Well, off the record.
Greg Gilbert, attorney of that. Mr. Stanford, Mr. Stanford appears to my right.
We're on the record in People versus Standby, case number 23520. And how do we want to proceed today?
We're proud you're on.
Ms. Toth, back to this.
Now, we can be ready in 30 days. We need 1 day for trial.
How much time do you
Probably the whole thing today.
agree with 1 day?
Yes, I think we can try the whole thing today.
Okay. Ms. Toth,
No,
We'll set it for a 1 day jury trial.
Are we looking, Your Honor, would you have a guess as to March or April? Would that be the time period?
Probably, yeah.
Thank you very much, Your Honor.
And then the court will set it for a final status conference. So to the extent that either side has motions, it can be filed at any time, but it would need to be filed and heard no later than that date of the final status conference. That'll also act as a plea cutoff. So if there are any further questions.
Thank you, Your Honor. Good seeing you, Your Honor.
1 second, Ms. Coke, anything further from you?
no, thank you.
Thank you. Well, today.
Thank you, Your Honor. Good seeing you. Have a good day.
Christmas songs in your head are?
I love Christmas.
Mr. Kermit, I'm going to call Mr. Wood's case 35201.
You have him on Zoom, Judge?
What's that?
Is he on Zoom?
He is not.
Okay.
So we're well past the time of the hearing. Mr. Gerber, if you could just make a record of what your last contact or information on Mr. Woods is.
Yes, Judge, I spoke with Mr. Woods a couple of weeks ago. I can give the court the exact date if I check my online access on my phone for a second. I spoke with his attorney in Oakland County as well. Oh, I spoke with him on 10/26, I'm sorry, 10/23 and 10/16. And I spoke with his attorney on 10/16 as well. And he is on probation in Oakland County. I talked to him about his guidelines in this case and his plea offer. The offer has been the same, nothing's changed. I know Mr. Woods indicated to the court and asked for permission to appear by Zoom the last time the court granted him that permission. I had all reason to believe he would be here, so I'm not aware as to why Mr. Woods is not here. I know at the last hearing, there was some issue of whether he had disclosed police contact here in Crawford County to his agent in Oakland County. I'm assuming that that was done since I spoke with his attorney and advised Mr. Woods to do that. I think the court advised him to do that as well, and I don't know if he's in jail because of that reason or not. I haven't had any contact with him then, at least in the last 30 days.
Thank you, Ms. Cope. Or Mr. Haven, did you have something?
Your Honor.
Any other information?
Since he is on probation, I looked up his record. He had a probation violation hearing on 11/6, and he failed to appear and a bench warrant was issued.
Okay.
I don't see any indication that he was picked up yet.
Okay, thank you. That's really helpful. Ms. Cope, I guess I'd be asking for you to prepare a bench warrant for Mr. Woods' arrest based on the lack of contact. So once we have Mr. Woods arrested, brought before the court.
We will prepare that FTA warrant, Your Honor.
Mr. Slap.
Mr. Slapp is here, who are you, Judge?
Yes, we have FTA warrant today.
Okay, we're on the record.
Jenny Allen.
People versus Slap.
Well, I don't do that.
It's already done.
5211 and 5272. Record to reflect Mr. Slap. These files? Mr. Mertz, we do have an open bench warrant for Mr. Schlapp that was signed by the court back on October 17th. As to file number 5211.
Yes, Ms. Medler indicated that to me. I've indicated that to Mr. Schlaff as well. I don't know if the court wants to arraign him on that issue. He's here in person. Clearly, he's not. He was here at the district court matter as well for the other file that was bound over. We're going to tender a plea, so I don't know how the court wants to address that.
What were the bond conditions that were?
I believe Mr. Schlupp was testing positive for alcohol.
All right, what is the, what's the plea agreement?
Judge, in the 5211 file, Mr. Schlaff would plead to operating while intoxicated, third offense. If he is successful with the Lions Den program or sobriety court, which we anticipate will be the Lions Den program, he would then be allowed to withdraw his plea to the third offense after completion and enter into a new plea as to operating while intoxicated, second offense. In the new file that was just found over with the resistant obstruct, he would plead to an attempt resistant obstruct, which is a one-year misdemeanor. That would be the entirety of the plea agreement for both files.
What's the status? And Mr. Schlapp may be able to speak to this better. Have you already been accepted into the Lions Den program, or do you know what the status of that is?
I'm paying it tomorrow.
What's that?
I have an appointment tomorrow.
Okay. All right, but you haven't been, they don't have a bed for you as far as you know.
No, it's hard.
All right, Ms. Koch, is that a correct statement of the plea offer?
It is a correct statement of the plea offer. It wasn't until today that I heard about the Lions Den. This case has been pending for quite some time.
Okay, but that's the offer that you made if you were to successfully complete that program.
Yes, if he were to successfully complete it.
Mr. Schlapp, did you want to go forward with that plea agreement today?
Yes, sir.
You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. Are you currently on any kind of probation or parole? All right. And you understand that the maximum possible penalty for operating while intoxicated, third offense, is up to 5 years in prison and or a $5,000 fine. And that the maximum penalty for attempted resisting or obstructing is up to 1 year. With those penalties in mind, what is your plea to those charges today? So right now you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you if you're at trial, and to question those witnesses. You have the right to have a court order any witnesses on your behalf if you're at trial. You have the right to remain silent during a trial, not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all those rights?
Yes, sir.
And you understand that you're giving up and waiving all of those rights by pleading guilty. Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to do that, you would have to ask the next higher court, called the Court of Appeals. You have to ask them to hear your case. They could say no, and then that would be the end of any appeal. You understand that?
Yes, sir.
Has anyone threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what we said here at court today?
No.
It's your own free choice to plead guilty.
Yes, sir.
And are you pleading guilty because you are guilty of each of these crimes?
Yes, sir.
Okay, so looking at the operated while intoxicated offense, that information indicates that happened on May 31st of this year. Is that the correct date? On that day, had you been consuming alcohol?
Yes, sir.
And after you consumed alcohol on that day, did you operate a vehicle on North Down River Road here in Crawford?
Yes, sir.
And did you have any blood or breath tests to determine the level of alcohol at that time in your system? Remember what the result was? Was it over 0.08? any reason to doubt the accuracy of that test. And had you previously been convicted of operating while impaired in the 53rd District Court back in 2008? And also of operating while impaired in April of 2023 here in the District Court of Crawford. Okay. And then moving on to the resisting and obstructing incident that happened on or about October 10th of this year.
Yes, sir.
And on that date, did you have some contact with the Crawford County Sheriff's deputy?
Yes, sir.
Was that individual wearing his police uniform?
Yes, sir.
Did you know that at the time that you encountered him, that he was performing his duties as a police officer?
Yes, sir.
And did he give you some commands? Did you have, was it physical resistance? What happened?
That's in this physical. Tighten it up, kind of.
Okay, was he in the process of arresting you for something? And you were resisting suddenly physically from the handcuffs? Is that?
Yeah.
And that happened here in Crawford County? Ms. Koch, are the people satisfied with the factual basis?
Yes.
Mr. Gerber?
I am judge with the new father, with the resistant obstruct. I just want to make sure you and the court took testimony for the full crime, that it would be an attempt.
Yes.
Okay.
Right. I just took the factual
Yes.
basis. Yeah.
Thank you.
Ms. Koch, are the people aware, I'm sorry, are the people satisfied that the court has complied with statute or rule in taking this plea?
Yes, Your Honor.
Mr. Gerber?
I am the judge.
That the court finds that your plea is knowing, voluntary, and accurate, or is satisfied that there is a factual basis to support a finding that you are guilty of each of these charges. The court will accept the guilty plea as to both. Because there is an open bench warrant and the court is going to order that you be taken into custody today. We're going to set this matter for sentencing. You can get a bed into the lion's den. Mr. Gerber, you can contact the court. I think the priority would be to get you into some treatment, but I want to make sure that we don't have any other incidents between now and then. Given your previous bond violations, I think for now, having you in custody is the safest place. So that's what we're going to do. The court will set it for sentencing. If you're eligible for the lion's den, you have a bed there prior to the sentence, we can look at doing that early. Otherwise, that would be something that the court obviously will consider as part of the plea agreement for purposes of sentencing.
Just is the court going to revoke bond on both his files?
Yes.
So you get credit for both?
Correct. Yeah. Ms. Koch, anything further we need to address today?
No, thank you.
Mr. Gerber?
No.
Mr. I'm going to have to go with the officer here. Mr. Thompson, are you ready to enter your office?
I am.
What's that?
I don't see.
Sir, what's your name again? Stump?
Sorry, Mr. Stump before he's called. Oh.
Right, let's take a short recess and we'll come back on the record in about 10 minutes.
I think so.
People versus Shepherd, case number 235179 and 235180. Present here today. You filed a motion to withdraw. You're not appointed, right?
That is good. I was not appointed.
Oh,
No, he's not my attorney.
let's. It's not, but I'm in the middle of talking to him right now, so please don't.
My bad.
You filed a motion to withdraw in this case. Is there anything that you want to state to support that?
I was just simply state, Judge, there's been a breakdown in the attorney-client relationship. So I'm gonna ask that you allow me to withdraw from this matter.
Mr. Shepherd, based on your comment, I'm assuming you don't have an objection. Okay, so Mr. Gerber, did you already?
I submitted it by way of an ex parte. I don't know if you would like to sign that, or I can
Okay,
submit a new one.
I probably have it, so I'll sign it.
Okay.
And if you need a copy.
I can just present it right now, Judge, if that's all right. 5 minute report for both files. Thank you.
So, Mr. Shepherd, how did you want to proceed in terms of representation?
I have hired Sam Bernstein.
Do we have an appearance from anybody yet?
Judge, I have nothing on this case.
Okay, so you're gonna need to have your lawyer, your new lawyer file an appearance with the court. They'll know how to do that.
Okay.
And we have a trial set for December 14th, so you're gonna want to have your attorney later. And we'll plan on proceeding with trial on the morning of the 14th. Ms. Coke, are the people going to be ready to go forward?
Yes, Your Honor. It's a consolidated trial with both of the cases. The prior attorney did not object to that. And so we're prepared to go forward on the consolidation.
Okay, so I'll just ask that you submit your proposed jury instructions prior to the trial date. Anything else that we need to address from your side?
No, Your Honor.
Mr. Shepherd, did you have any questions?
No.
Did I remove Mr. Gurmurthy as attorney? So right now he's pro per until I get an appearance. Is your address still 707 Larson Court?
Yes, it is.
Okay.
All right, so again, have your new attorney file an appearance, and then you'll need to be here at 30 on the morning of Thursday, December 14th. Okay.
For trial.
Yes.
Okay.
All right, thank you.
Oh, can we get a written copy of this?
What's that?
Of the trial date?
You have already been mailed a copy of that.
Can I get a physical one from this court?
Can you wait to get a copy?
Yep, you can have a seat out in the lobby. When we take a break at the end of the day, I'll get that for you.
Perfect, thank you.
Mr. Thompson, you ready on Mr. Ackerman's case?
I am. I don't see Mr. Ackerman here, Your Honor.
All right, we'll call that matter People versus Ackerman, case number 235232. Set for hearing 3:45, 4 p.m. Mr. Ackerman, Mr. Thompson contacted you recently. Or was it the last time we were at?
I don't recall exactly, Your Honor.
Last month.
Yeah, I last month. Or Your Honor, last month. I think my partner had contact with him on a different case approximately 2 weeks ago.
Ms. Coke, people taking a position on how to proceed today.
I don't suspect he fled. Mr. Ackerman lives in this community. I don't know that he's had any prior fails to appear. Let me look. He has not. I've met with defense counsel. We've talked about a plea offer. I provided it to Mr. Thompson. Him and I watched the video together last week. The sections he wanted me to see, we're prepared for trial. I don't, if the court wants to do a bench warrant for failure to appear.
See any priors in that mail return from September. Well, it sounds like you've had court since then. The court will set this for a show cause at the court's next available date. Mr. Thompson, if you could contact Mr. Ackerman.
I will, thank you.
Let him know that he'll need to have an explanation for his non-appearance today at that next hearing. versus Stump, case number 235258.
Senator, to the podium, Mr. Chairman.
Present here in court today. This is set for a status conference. Where things are at.
Yeah, I did receive a plea offer in this matter. Mr. Stump pled guilty to 1 count of felonious assault. The prosecutor would dismiss counts 1 through 3. I'd ask if we could have 30 more days to review that offer at that time, set the matter for trial. Your Honor.
Hope there's not any objection to that.
No, Your Honor.
Mr. Stump, do you have any objections to that?
No, sir.
So, Mr. Stump, we'll have this set for a status conference plea hearing. At that point, I'll just need you to have made a decision about whether you want to go forward with the plea or with trial, okay?
Yes, sir.
Do you have any questions?
No, sir.
Thank you. And then, Mr. Thompson, when you're ready on this. Please.
Yes, Your Honor, thank you.
Want to come right up to the podium, please? Case number 235254. Record reflect Mr. Apple present here in court today. This is the date time set for sentencing. Did you have a chance to review the report? Mr. Thompson, are there any additions, deletions, or corrections to that report?
No, Your Honor, thank you.
Are there any changes to the scoring of the guidelines?
No, Your Honor.
Do you have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring of the guidelines?
No, Your Honor.
Anything on behalf of the people, do you have any victims that wish to address the court?
We have not heard from Pizza Hut at all. They have not responded to us. So we do not have any victims.
Anything on behalf of the people for allocution? No.
You know, Ms. Schlaff presents as 29 years old, and when I see somebody who has no juvenile record, 1 misdemeanor, no felonies, and then all of a sudden they're charged with, you know, meth, I wondered to myself, how did I get into this position? This money looked like play money. I don't know why she would try to use it. You know, she had her 4 children taken away. So she started using meth in 2022. I don't think anything this court can do is going to impose is going to be worse than having your children taken away. She is working with CPS. She apparently has a new job. She doesn't know this, but I actually know her daughter. Very nice child. And I'm hopeful that she's able to get her life together. I mean, her kids are pretty young and they really do need a mom. Anybody that's on meth, frankly, we see them go through this court. Very few of them are successful. CPS has a very strong oversight on people who want to get their kids back. They have to go through a lot of hoops, probably more than even felony probation. So I think the recommendation is appropriate. I hope that she is successful, and I hope that she realizes that this is not the path she wants to go down. Thank you.
Thank you, Mr. Thompson. Anything on behalf of Ms. Schlaff?
Your Honor, I echo the prosecutor's statements. I am representing her on an NA case. She is on that track to try to essentially demonstrate to the Department of Health and Human Services that she should have her children placed back with her. That's her motivation. That is a very intensive program, with a lot of testing, a lot of oversight, a lot of services. I think that's the best option for the court, at least initially, to review how she does in that program. I think the recommendation is appropriate. I've asked the court to adopt it.
Ms. Schlaff, anything that you wanted to say today? No. Okay, I did read through the report, so I'm familiar with what happened here that brings you before the court. And, you know, as Cole pointed out, you don't have really any kind of a prior record. You're still a young person. There's a lot of room for rehabilitation here, trying to get you back onto the right path. And so I think based on your circumstances, that's the way the sentence should be geared. And so I think the recommendation is an appropriate recommendation. It calls for jail time, time served, no additional jail time up front. It calls for a period of probation under 7411, which would give you an opportunity to successfully complete it, to not have this be on your public record, which would be a big deal in a lot of ways going forward. So I hope that this is, kind of a wake up call to try to get things in line. This is the time to do it now rather than later when things are further down the road. So I am going to follow the recommendation. The court is going to place you on probation for a period of 18 months. The court's going to adopt as the conditions of the probation all the terms and conditions listed in the report. The most important one, of course, is that you can't use controlled substances unless they're prescribed to you. And that you not be around people who are using substances. This is important. Recognize that people that that's why that's or is going to make it condition probation pursuant to 7411. The court again is going to impose 5 days of jail with credit for 5 days served, restitution in the amount of $dollars. Several with Tyler Ray, able to the Crawford County Clerk to be dispersed to Pizza Hut. $30 in crime victims assessments. For a cost of $325, attorney fees $50, state cost of $68. While you're at probation. And that all relates to count 3, the possession charge, count 4, retail fraud, $50 state cost, and 5 days for credit for 5 days. You have the ability to appeal the sentence, or I'm sorry, no, 7411, so there are no appellate rights. You need to check in with Mr. Hayden before you meet here today. He's going to explain to you how to go forward. So is there anything further we need to address on this file?
No, thank you.
Good luck to the court. John.
Okay.
That concludes our docket.